Greetings and welcome to Property, Procedure and Actions from American Jurisprudence. I hope notifications went out. I didn't get one. I hope all you did. Otherwise, for you that are here, greetings. So we're going to be reading from American Jurisprudence, second edition, February 2022 update. And we'll also have at our ready Black's Law Dictionary, 9th edition, to make sure that we leave no word behind. With that said, let's get started on property, procedures, and actions. All right. The law presumes that the infringement of a property right is harmful and sustains a remedy to vindicate that right and prevent future harm. The rules and principles relating to actions generally apply to actions relating to real property with the same force as to other actions. So real property as opposed to movable property. Observation. Courts strongly disfavor the resort to forceful self-help in resolving property disputes. Forceful self-help. Well, that's footnote 3, and that's going to be this case here from 2014. Ackers versus D.L. White Construction in Idaho. This would be an interesting case to look up there. All right. And that's kind of current within the last 10 years. As a general rule, only the owner of the fee has a right of action for damages to the fee. And that's from footnote 4, and that's from 1911. So this is long-standing. So let's look at this now a little bit more closely here. As a general rule, only the owner of the fee, and you might ask, well, what is a fee? And that's a good question, in which case we should come over to Black's Law Dictionary to find the exact definition of that. There's Black's Law. All right. So let's see if we get somewhere around there. Let's see, where are we here? Okay, pretty close here. Federal. Here we go, fee. from the 14th century, a charge for labor or services, especially professional services. But I don't think we're talking about this particular one here in definition 1. They have all these different fees here listed under definition 1: jury fees, maintenance fees, organization fees, success fees, witness fees. But here's definition 2 of fee. And I think this is the one that we're referring to in the text. A heritable interest in land, especially a fee simple absolute, also termed fee estate, feed, feudum, feudum, see fee simple. So let's look at this. And if someone was to transfer to him an interest in land called a fief, and fief, that's it. And fief someone was to transfer to him an interest in land called a fief, or if you prefer, a fief, feed, or feud. Our modern word fee, a direct lineal descendant of fief, implies the characteristic of potentially infinite duration when used to describe an interest in land today. But in the earliest part of the feudal period, a fief might have been as small as a life interest. We shall see later that the fiefment was not used to transfer interest smaller than life interests. An example given here, so-called terms for years. But for our purposes now, we may simply note that transfers of interest for life or larger were accomplished by livery of season. So this tells us that the fief, a fee, right? It's the ownership of land or an interest in land that's at least as long as a life interest and could be larger. Now it says that was not used to transfer interest smaller than life interest as in terms of years. I think that'd be a lease, right? But that being said, we should know now that fee simple, right? It's a heritable interest in land, especially a fee simple absolute. So let's see here. We probably have fee simple on here too. See fee simple. Well, yeah. Fee simple, here it is. Again, 15th century. An interest in land that, being the broadest property interest allowed by law, endures until the current holder dies without heirs, especially a fee simple absolute, often shortened to fee, also termed estate in fee simple, tenancy in fee simple title, exclusive ownership, feudum simplex. So, a fee simple is a term not likely to be found in modern conversation between laymen, who would in all probability find it quite unintelligible. Yet to a layman of the 14th century, the term would have been perfectly intelligible, for it refers to the elementary social relationship of feudalism, which he was fully familiar. Let's zoom in a little bit more so you guys can read along on this highlighted area. The words fee and feudal are closely related. The estate, in fee simple, is the largest estate known to the law. Ownership of such an estate being the nearest approach to ownership of the land itself, which is consonant with the feudal principle of tenure. It is, in quotes here, the most comprehensive estate in land, which the law recognizes. It is the most extensive in quantum, that's an immeasurable amount, that the most absolute in respect to the rights which it confers of all estates known to the law. Traditionally, the fee simple has two distinguishing features. First, the owner, the tenant in fee simple, that's the owner is the tenant. Look at that. Has the power to dispose of the fee simple, either inter vivos or by will, so either while they're alive or by the will. Second, on intestacy, meaning if they didn't have a will, the fee simple descends in the absence of linear heirs to collateral heirs, to a brother, for example, if there is no issue. Fee simple. Originally, this was an estate which endured for as long as the original tenant or any of his heirs survived. Heirs comprise of any blood relations, although originally ancestors were excluded. So the older ones were excluded if they were blood relatives. He had to be a younger relative, it seems, or not necessarily younger, but not an ancestor lineage. It had to be, I guess, a cousin or something like that. Not until the Inheritance Act 1833 could a person be the heir of one of his descendants. Thus, at first, a fee simple would terminate if the original tenant died without leaving any descendants or collateral blood relations. An example given is brothers or cousins. Even if, before his death, the land had been conveyed to another tenant who was still alive. But by 1306, it was settled that where a tenant in fee simple alienated the land, the fee simple would continue as long as there were heirs of the new tenant, and so on, irrespective of any failure of the original tenant's heirs. Thenceforth, a fee simple was virtually eternal. So, guys, fee simple absolute, an estate of indefinite or potentially infinite duration. Those are heavy words there. Example given, to Albert and his heirs, often shortened to fee simple or fee. All right, so we had a nice little digression there, and I think we got a good, here also termed fee simple in possession. Can't finish it here, although it is probably good practice to use the word absolute whenever one is referring to an estate in fee simple that is free of special limitation, conditions subsequent, or executory limitation. Lawyers frequently refer to such an estate as fee simple, or even as a fee. All right, so there's our deep dive into fee simple and fee itself. All right, let's get back to the text and check over here in the chat. Let's see if y'all stuck along for that digression there. If everything's loud and clear, let's continue. All right. So, as a general rule, only the owner of the fee has a right of action for damages to the fee. A trespass on a right of property is actionable upon any physical invasion of it, regardless of whether the invasion causes measurable damages. And an owner, whether he or she is in possession or not, may recover for injury to his or her property by the negligence of another. Further, the owner of any particular right, interest, or estate in real property, including one rightfully in the occupancy or possession of the realty, has generally at least a right of action for damages for injury to his or her particular right, interest, or estate. Thus, the holder of a non-possessory interest in property can generally sue for damage to that interest. So, what we got here, let's break this down a little bit here. And the footnotes are just cases, so let's look through here again. So the trespass is actionable upon any physical invasion, whether it causes damages or not. So a right trespass on a right of property. Interesting. An owner, whether he or she is in possession, may recover for injury by the negligence of another. So whether you're actually in possession of the property or not, as long as you're the owner, right? The owner of the fee has a right of action. So the owner is the one that would have the action against someone that caused negligence or trespass or other kind of damage, physical invasion. Further, the owner of any particular right interest in real estate property, including one rightfully in occupancy or possession, has generally at least a right of action for damages for injury to his or her particular right. So, in other words, the holder of a non-possessory interest, could be a renter, I guess here, can generally sue for damage to that interest. So maybe his use of it could sue someone else, or could get into that. But that means that their interest can only be limited to their particular right or interest, not that of the estate in general, just to their interest of that, right? All right. So it seems to me, but again, don't consider this anything as beyond the purposes of the entertainment educational broadcast of this YouTube channel. This is not to be used, construed, or misused for any kind of legal, lawful, personal, professional, financial, tax, or otherwise advice. Do not do this at home. Let's proceed. Before we do that, let's check over the chat. All right, we have Christopher Real out there. Welcome. And Chris, for real, are you talking about property taxes yet? We're talking about property in general and what law governs in actions involving property. So this would be a basis, a foundation before you would get anything tax related, I believe. So this is a very important presentation to pay attention to as we go deep into all these definitions and understanding about the laws governing property, procedures, and actions. Let's continue. State law creates and defines property rights or interest. So state law defines and creates and defines the property rights or interest generally. Questions involving ownership of land are determined under state law, even when the federal government is a party. And the law of the situs of the property controls. So what is the situs? The situs, we could look into Black's Law. Let's do that and make sure everyone is aware of what situs means. Let's interact here and get down to where S. Bear with me here. This is a little slow as it scrolls through because this is a scanned image. Look, the Royal Marriages Act, 1772 statute forbidding royal families marrying without the sovereign's permission, except on certain occasions. All right. Here we go. Situs. Here we go. Latin. Let's see if it's on the screen here. 1834. The location or position of something for legal purposes, as in lex situs, the law of the place where the thing in issue is situated. See locus. Tax situs. See tax situs. So when it comes to property tax, this is the foundation of where the legal purposes of that applies. So situs is a critical term to know, the location or position of something for legal purposes. I believe the actual root of this, and I'm surprised there's not more etymology of this that would actually even refer to a site of a crime. But I digress. Let's get back. So you could think situs, situated, it seems related to. But that's just my speculation. Let's continue. All right, so the state law creates and defines property rights, and it's the law of the situs of the property that controls that. And more specifically, the law of the state in which the real property is located covers the questions of property rights. And for personal property, including intangible personal property, its situs is at the domicile of its owner. That's footnote 5. Delaware and New York, Haynes. Okay, so these are all cases here. Let's see, 4 will have a little bit more in there. That was on the law of the state. Clearinghouse. Wow. You applying Florida law, Wells Fargo. This is 2015. Interesting here. That's footnote 3. The law of the state. Or I'm sorry, that's in the law of the situs of the property controls. And we have universal clearing in Utah in 1986. Also, let's see here. 84. Oh, pardon me. Great. Give me a second here. All right, we're back. Apologies. Let's continue here. All right, so looking through here, we have the law of the situs shall exclusively govern in regards to all rights, interests, and titles in and to immovable property. So the law of the situs, so anything that's immovable, the law of the situs will exclusively govern. Nice. All right, so that's our cases there, plenty of them, 2004, 2016, 1984, lots of states, 86. And then we have the one here that the law of the situs of the property controls also. So, thus the validity of a conveyance of a property interest is governed by the law of the place where the property is located. And in determining the ownership of the property, the courts apply the law of the jurisdiction in which the land is located. Now listen to that different language there, and that's Turner versus Mullins in 2005. So the validity of a conveyance, when you're transferring that property, the conveyance of a property interest is governed by the law of the place where the property is located. And in determining the ownership of the property, the courts apply the law of the jurisdiction in which the land is located. Wonder if it's on federal land. That'd be an interesting test there. All right, I digress once again. Let's continue. All right, before we get on to Section 48, the pleading and actions involving property, let's check over here with the chat. Territorial jurisdiction, exactly. The situs is it will be your territorial jurisdiction. Citizenship. All right, let's continue here. Oops, come on, get back here. There it is. All right. One's ownership of real property may be sufficiently alleged by an averment that he or she was seized and possessed of the land. Oh gosh. All right, so we have an averment, which is a statement of truth or fact. Now, what is this seized here? Now, this has got me a little worried. Let's check over here with our good friend, Black's Law Dictionary. We're close enough to the SE to find that, so let's find that. I don't know if that's seized with a Z or not, and just an old spelling, but we got to know. So let's see here. SEC, here, securities, close. Seduction, C, here we go. All right, so we have C's with a Z. And season. And here's a C's without the Z. Verb, to invest with season or establish as a holder in fee simple. To put in possession. Look how different that is than the word C's with a Z. It's pronounced the same, C's. That's legalese for you. So season, just like seasoning your food. 14th century, historical. Completion of the ceremony of feudal investiture, by which the tenant, remember the one that one that lives on the fee, the tenant, was admitted into freehold, and the owner was admitted into freehold. So freehold meaning holding for free, no encumbrances, right? Possession of a freehold estate in land, ownership. And Louisiana law, the right that the law accords universal successors to own and possess a person's estate directly and immediately upon that person's death. Wow. So originally season meant simply possession, and the word was applicable to both land and chattels. Prior to the 14th century, it was proper to speak of a man as being seized of land or seized of a horse. Wow. Gradually, season and possession became distinct concepts. A man could be said to be in possession of chattels or of lands wherein he had an estate for years, but he could not be said to be seized of them. Season came finally to mean, in relation to land, possession under claim of a freehold estate therein. The tenant for years had possession, but not season. Season was the reversioner who had the fee. And although the word season appears in modern statutes with a fair degree of frequency, is usually treated synonymous with ownership. It is difficult to define season satisfactorily. Okay, so now we see why we're spending so much time on it. It has nothing to do with seizing, with its implication of violence. To medieval lawyers, it suggested the very opposite: peace and quiet. A man who was put in season of land was set there and continued to sit there. Season thus denotes quiet possession of land. So I guess this is also where we get quiet title. But quiet possession of a particular kind. Although it seems impossible to frame a satisfactory definition, to call it that feudal possession of land which only the owner of a freehold estate in freehold land could have, is to express the most important elements. Freehold. Important concepts to think of. So season, and think of this now. So quasi-season, a copyholder's possession of lands, the freehold possession being in the Lord. Season indeed, actual possession of a freehold estate in land by oneself or by one's tenant or agent, as distinguished from legal possession. Actual possession. And that's a 17th century one, cases in property. So this is quite a deep dive here into season in law, the right to immediate possession of a freehold estate in land, as when an heir inherits land, but has not yet entered it. Season in law is when something is done, which the law accounteth a season as an enrollment. All right, so a seizor is one who takes possession of a freehold. So a seize is to invest with season, with a freehold estate, or establish a holder in fee simple, to put in possession. So seize means to put in possession. It also means to forcibly take possession. I mean, how opposite can you get for the exact same word other than sanction? All right, so I hope that confuses everyone enough to understand what you need to know if you have to deal with this stuff in any other context other than this YouTube channel. And let's proceed from here. All right, so now we've ceased that word's definition, taken possession of it and not left it behind. All right, so one's ownership of real property may be sufficiently alleged by an averment that he or she was seized and possessed of the land. So you got that inheritable or otherwise ownership of possession and of title, it seems, of the land, a declaration, or complaint should describe the real property in a suit with sufficient particularity to prevent the defendant from being misled or uncertain as to the location of the property. So, meets and bounds, I guess, things like that. That's 1899, indeed. Alaska. Liberally read, a complaint of a dog owner against a city, alleging that a city police officer shot and killed the dog, encompasses a claim for damages for property loss. Let's read this again. Liberally read, a complaint of a dog owner against a city, a complaint meaning a petition in court, filed in court, alleging that a city police officer shot and killed the dog, encompasses a claim for damages for property loss. The dog, huh? That's city of Racine. That looks like Wisconsin, 2001. Dog killer. Terrible. Why would they do that to the dog? All right. Let's move along here. There we go. Section 49, proof of ownership of property, generally. All right, let's hop over here to the chat and get this refresh. Oh, yeah. Oh, gosh. This thing was really stalled on me here. All right. Castle Doctrine. We might get into that some later on here, too. C. State defines property laws only for state-regulated property, I would think, such as forts, magazines, arsenals, properties used for interstate commerce. Well, as far as the ownership and title goes, you know, you get the sheriff, and if there's judgments and everything follows due process, it follows the due process of the state as far as when there's a controversy as of ownership or claims of ownership of property. So that's going to be adjudicated according to the situs or where the property is situated, the location there, to their jurisdiction and to their laws. So that's generally held. Remember, we're taking a perspective here from American jurisprudence, which is foundationally of American common law, and mixed in with the rest of the statutory and the other amalgamations of legal additions that have attach themselves to that tradition. However, it is unique to America, so this is something that is worthy of getting a good full comprehension of to see how it applies. All right, let's continue from here on to the proof of ownership of property generally. So how do we prove ownership? The ownership and possession of land must be proved by evidence and cannot be proved by general notoriety or by reputation. While the legal title to real property can be shown by a valid deed, the record title is the highest evidence of ownership of real property and is not easily defeated. When the issue of title or ownership is directly involved, the proper way to prove title to the property is the production of the original documents or certified copies from the record. The payment of taxes for real property is not evidence of title and ownership. Further, it has been held that title opinions are not evidence of title. So we have here, that's footnote 6, and that's Blair versus Bishop, 2008 in Georgia. And I know we had and the British common law was at the base of our laws, but it's quite different, and they don't even follow that anymore. So America is the last vestige, you could say, of common law, and it's probably our greatest strength, really, in as far as our tradition of law goes. There was a question here. Christopher Reel was asking about that. So as you can see, property taxes is interwoven within this subject here. So again, like I said, just pay attention here. You'll see some real gems in here. Okay, so as we were seeing here, that the evidence, right, of possession, right, you need to have evidence of that. And it can't be proved just by reputation or notoriety. Remember, a notorious occupation as adverse possession alone isn't enough. There has to be some kind of evidence, like perhaps a color of title or something. All right? And that's while legal title to real property can be shown by a valid deed, the record title, right, the actual recorded title, is the highest evidence of ownership of real property and is not easily defeated. So again, the purpose of having valid deeds recorded is to allow the marketability of property, so it's not wasted away and it's always maintained and upgraded and improved, and that the encumbrances are clearly documented within the deed, so that when it's transferred, the title's transferred, it's clearly established that there's no legal encumbrances to that transfer, so it could be done with little risk in the transfer itself or the conveyance. All right, let's see here. Let's refresh this here and let's continue. All right, there we go. There are circumstances when testimony alone can be sufficient basis to establish ownership of property. Really? That's Pesmore Investments LLC versus Grupo Levy and Company, and that's 2016. Huh. When determining ownership for personal property with no formal title, oral evidence from a witness with knowledge concerning ownership of such chattels is competent evidence of the fact of ownership. So this is chattels, though. That could be the paper, the documents it could be referring to. All right, that's footnote 9, and there's nothing further on that, but that's 2010, Renaissance Learning or Leasing LLC versus Vermeer Manufacturing. All right, and we're on to section 50, the burden of proof. The burden of proving title of ownership of real property is upon the party alleging it. The burden of rebutting a prima facie showing of title rests upon the party attacking the title shown. And another person who claims ownership to that property must establish the claim by clear, satisfactory, and convincing evidence. And that's footnote 3, 2012. As a general matter, title to estates and land should be altered only by clear expressions of intent. That's applying New York law. So the burden of proving title or ownership of real property is upon the party alleging it. The burden of rebutting a prima facie showing of title, meaning you show the recorded title, highest evidence, rests upon the party attacking the title shown. And another person who claims ownership to that property must establish the claim by clear, satisfactory, and convincing evidence. So if that's what they have to do to rebut the prima facie showing of title. All right, pretty good there. Let's go on to section 51, presumptions. Oh boy. This gets messy here. And let me refresh the chat here, make sure everyone's still with me here. Wow, hang on a second. Give me just a second here to refresh all this here. Goodness. All right, we're back. A record title or legal title is an indicium sufficient to raise presumption of true ownership. So that's your presumption of true ownership is the record title or legal title. Footnote 1, applying Kentucky law 2005 applying Montana law and holding that a person possessed of the record title is presumed to be the lawful owner of the property as the form of title presumption, see section 28. All right, so we see here the record title or legal title is sufficient for the presumption. Under similar authority, a deed is prima facie evidence of a grantee's ownership. Thus, generally, there is a rebuttable presumption that the person whose name appears on a legal title is the property owner. The presumption that the party with a legal title to the property is the owner of the full beneficial title promotes a state's public policy in favor of the stability of titles to property and the integrity of the property transactions, as I said before, the marketability. So we have that's footnote 4 for additional opinion applying California law. Possession of real property is prima facie evidence of ownership. Similarly, possession of personal property creates a rebuttal presumption that those in possession of property are rightfully in possession. Wow. Thus, possession of personal property creates a rebuttal presumption or prima facie evidence of ownership. That is, evidence of possession of personal property ordinarily constitutes some evidence of ownership, which may be overcome by proof of ownership in another. The name on tools, vehicles, or animals in articles generally is commonly accepted as prima facie proof of ownership, and although not of much probative weight, it is enough in the absence of evidence to the contrary to carry the issue to the jury. Wow. So see here, the name on tools, vehicles, the name in articles is commonly accepted as prima facie proof of ownership. So put your name on your vehicles or animals. Name on animals, I guess that's branding. Wow. All right, so that's footnote 11. Let's see how old that one is. Cannon versus Motors Insurance Corporation, 1951. Writ dismissed. 1953. Wow. All right. Good stuff. This rule is recognized and applied to various species of property, and it has been applied in actions for damages sustained through an instrumentality bearing the defendant's name. Likewise, the brand or mark on a cattle is prima facie proof of ownership in states where the legislature has permitted such branding by statute. So if it's allowed by statute, it can be used as prima facie proof of ownership. But if it's not permitted by statute, then you shouldn't be branding those poor animals. Property is presumed to descend to their heir. Here's our presumption. In the absence of any proof to the contrary, the presumption is that a deceased person died intestate, without a will, and that his or her heirs become the owners of all his or her property. Exercising acts of ownership over property is the basis for a statutory presumption of ownership in some jurisdictions. Let's see at footnote 15. And okay, descent and distribution. All right. So there we get our presumptions. We had the record title is sufficient to raise a presumption of true ownership, to raise a presumption, right? The deed is prima facie evidence of a grantee's ownership. There's a rebuttal that the name, right, the person whose name is the property owner. Presumption is that, so there's a rebuttable presumption, the presumption the party with legal title is the owner of the full beneficial title, and promotes state's policy in favor of stability of titles, property, so for marketability. Then here's another presumption, possession of real property is prima facie evidence of ownership. So possession is 9/10 of the law. Is that what they I don't know if that's true or not, but I think that's what they're presuming here. Possession of personal property creates a rebuttable presumption that those in possession of property are rightly in possession. So that's better than 9/10 to me. The name on tools, another presumption, and a property is presumed to descend to the heir. All right, presumptions are very important as the form of title presumptions. See section 28. Oh, animals in American jurisprudence. That's going to be a tough read there. All right, we're on to motor vehicles, section 52. Generally, ownership of a motor vehicle. Notice the term here, not automobile. It says motor vehicle is generally determined by reference to the title certificate. Idaho law 2016. That's rather recent. Generally determined by reference. Wow, that's rather detached to a certificate. Not even the actual title, but the title certificate. A title certificate is prima facie evidence. It's not the title, it's evidence that the party named on the certificate owns vehicle to which it applies, or creates a rebuttable presumption of ownership. The party named which party, but it is not conclusive proof or the sole determinant of ownership of a motor vehicle. Under such authority, proof showing different ownership is admissible. Similar authority explains that certificates of title of automobiles are indicia of ownership and control, and that a certificate of title is merely evidence of title to a vehicle, not title or ownership itself. In other words, a certificate of title is not of itself proof of ownership or legal title to a vehicle. And a person may have legal title in a vehicle even though he or she does not possess a certificate of title. Wow. So we got a lot of footnotes there, and that's a lot to get out of American jurisprudence here. Let's see here. We got footnote 7, 2014, 2013, 2013, 2012. Looks like there's a good slew of them around that time. Interesting here. Let's take another look at this. Similar authority. Proof showing different ownership is admissible outside of a certificate, right? That a certificate of title is merely evidence of a title, not title or ownership itself, and that itself is not of itself proof of ownership to a legal title. And a person may have legal title even though he or she does not possess a certificate of title. However, other authority holds flatly that the owner of a motor vehicle is the person to whom a vehicle is titled, or the person whose name appears as such on a title certificate. Under such authority, indicia of ownership is only considered to determine ownership of a motor vehicle when no title has been issued to any party asserting rights to the vehicle. Oh, wow. Okay, so vehicle ownership is a fact question for the jury to determine in light of all the circumstances. Where there is conflicting evidence of ownership of a motor vehicle, the issue must be resolved by a trier of fact. Nice. So that's an interesting tactic there, applying California law 2010 and 2015. So the jury, it's a fact question for the jury to determine in light of all the circumstances. Evidence of ownership must be resolved by the trier of fact. Wow. All right, a little mind-blowing there, and that is the end of it, of course. So let's look down here at these footnotes. And before we do that, let's bounce over here to the chat. All right. Dan from Audit Erie County likes to inspect the oldest deeds that can be found at county clerks. Interesting history can be found there. Yes. These days we put our names inside our animals with microchips. Indeed, I guess that would be evidence. And I wonder when vehicle titles became known as pink slips. That was some time ago. So let's look at this. These citations here, because we have a few other notes here. The name on a vehicle's title raises a rebuttable administrative presumption of ownership. And of course, the insurance company, State Farm, is involved in that. So, a registered certificate of title establishes only presumptive ownership of an automobile, which can be overcome by competent evidence. And that's, wow. Florida's 5th District Court of Appeals, 2010. And an Estate Motor Vehicle Certification of Title Act is the exclusive method of transferring title to a vehicle, but it is not conclusive of ownership. Wow. So the certificate states Motor Vehicle Certification of Title Act is the exclusive method of transferring a title to a vehicle, but not conclusive of ownership. Interesting. And then we have, let's see here, motor vehicle title documents. Let's see, decision. Okay, so the are not unimpeachable evidence of ownership. Motor vehicle title documents are not unimpeachable evidence of ownership. So they can be impeached just because they're motor vehicle title documents. Title registration is rebuttable if evidence of ownership to the contrary is produced. Great cases, great information, and what a great ending with a little bit unexpected there to have in this as a bonus, as we're mostly talking about the immovable property or the real property. See, the term motor vehicle denotes commercial use property under the Motor Vehicle Act. Therefore, in the context, the term owner refers to a business owner, thus regulated and taxable. Yeah, or as a partner with the state that is registered to. That's the other aspect of it too. So when insurance is involved, that's where some of this is brought to light, I think, a little bit stronger, which is an important reason why some of these cases that are brought up here are involving insurance companies, because they're the ones with the, the pecuniary interest in these types of outcomes, and that's where they will enforce the law, where we, the people, need to be aware of this as well and enforce it for our own rights as well. Let's see what else we have here in the chat. Apologize, it hasn't been refreshing very well. There we go. All right. So I think we're there to the end of our presentation. It's been a enlightening and very interesting one on property in procedure and actions within the courts from the perspective of American jurisprudence and our fine tradition of American common law for the most part. Peppered with a little bit of statutory and regulatory types of interference and interloping. Nevertheless, still a tradition, the envy of the world. So one worthy of our attention and our dedication to ensuring it's still here for posterity. With that, I salute you all for being here, and I hope to see you all on the next one. Peace out.